Hello, my name is Benjamin Hart. I'm an American attorney. I'm the Managing Director of Integrity Legal here in Bangkok, Thailand. This blurb today is going to briefly discuss, or I should say sort of amend the previous video talking about the U.S.-Thai Treaty of Amity on this channel. I had some comments actually from some other legal professionals who had actually watched the previous video regarding the Treaty of Amity, and they sort of gave me some advice as far as making a correction, I guess. Essentially, in the title of the last video, I called it Foreign Business Licensing in the U.S.-Thai Treaty of Amity. There's some arguable difference in the actual way in which businesses are dealt with under the U.S.-Thai Treaty of Amity here in Thailand. So basically, it comes down to the difference between certification and licensing. Probably to a layperson that would seem to be something of a semantic point, but it's worth bringing up because by delving into the topic, we can sort of get into some in-depth notions of how the treaty operates, especially with respect to what's called the Foreign Business Act here in Thailand. So, very quickly, there's a difference between having an Amity certificate and having what is called a foreign business license. As a practical matter, they would sort of operate somewhat the same way, but there is a fundamental sort of legal differentiation between those two types of statuses here in Thailand. So, the U.S.-Thai Treaty of Amity basically is produced pursuant to the U.S.-Thai Treaty of Amity signed in 1966. This treaty supersedes, in effect, the Foreign Business Act, which actually came later, and there are provisions in the Foreign Business Act which basically stipulate that the Foreign Business Act itself can be overridden by international agreements or other types of Thai law. So the Treaty of Amity, in much the same way, if you want to look at it from an American's perspective, where a treaty which is signed by the U.S. President and ratified by the United States Senate, actually becomes the law of the land, thereby superseding other types of legislation, such as statutory law. A treaty operates much the same way here in Thailand. So you have the treaty, and then you have the Foreign Business Act, and because the treaty was signed and enacted, it supersedes the Foreign Business Act, and there are even provisions within the Foreign Business Act recognizing that such occurrences can happen and dealing with those accordingly. So, the main point I'm trying to get at here is when you get a foreign business license, you're getting licensed pursuant to the Act. When you're getting a Treaty of Amity certificate, you're getting a company certified as operating pursuant to the terms of the treaty, and in essence, they're operating notwithstanding the provisions of the Foreign Business Act. So the Act simply exists, the treaty exists simultaneously, but the treaty supersedes the provisions of the Act. So when we're dealing with U.S.-Thai Treaty of Amity companies, or companies formed thereunder, the certificate you get is somewhat different than what is called a foreign business license, which I will go ahead and do another video specifically on foreign business licensing. But to get to the point of it in this particular video, you have the foreign business license, which is getting a license pursuant to that structure. An Amity treaty is getting a company certified pursuant to the treaty and thereby avoiding dealing with the Foreign Business Act. Another thing to think about with respect to the treaty, or another thing so that we can kind of delve into which shows the difference between certification, is basically a company that is an American company under the provisions of the U.S.-Thai Treaty of Amity is to be given quote-unquote national treatment. And those companies are therefore considered to be literally legally equal to a Thai company, a company that would have all ties on the company. Now, the thing to keep in mind is that status must go through a certification. In order to get that status, you need to undertake a certification process. So the identity of the American shareholders needs to be disclosed, and then that needs to be essentially certified by the U.S. Commercial Service here, and then further certified by the Foreign Business Office in the Kingdom of Thailand. So it's a different process. It's a fundamentally different status than licensing under the Foreign Business Act. But it's of note because, yes, it's different, and it's a different process than one would undertake for the FBA and licensing thereunder. It's also different than what's called BOI, Board of Investment. But the Amity, yes, to be clear, Amity Treaty companies are not, strictly speaking, foreign business licensed. They are simply certified as being what they are, as in fact being American companies operating in Thailand, and pursuant to the provisions of the treaty, they operate with quote-unquote Thai national treatment. Another thing to think about with respect to the treaty is that there are certain exceptions. Not every type of business activity is going to be authorized pursuant to the treaty. So the exceptions are noted in the treaty itself. There's some vagueness as to what falls into what category, and for those kinds of matters, again, legal professionals are helpful in providing insight into how that works and how you're going to go about getting the company certified for the types of endeavors it wishes to undertake specifically, and how you go about getting that essentially all drafted into the treaty certificate itself. So again, licensing is a little different than certification. There is a fundamental difference in sort of the legal posture of a treaty company versus a foreign business license company. At the end of the day, once either one of those processes would finally be completed and one either had a foreign business license or a treaty certificate, the ultimate result of it is going to tend to be relatively the same. Essentially, a foreigner is permitted, or a foreign company, or a company that predominantly is owned by foreigners or operated by foreigners, is going to be allowed to operate here in Thailand prospectively into the future. So it's a difference of sort of legal posture. At the end of the day, as a practical matter, it's all going to result in the same thing, which is the ability to do business in Thailand legally, pursuant to Thai law and American law. And we're specifically talking about the treaty here. That this treaty goes both ways. There are certain provisions that allow Thais certain benefits pursuant to the treaty in the United States, most notably E2 visas, E1 visas under U.S. immigration law. There are also various other things stipulated in the treaty itself. So this is a two-way thing. Essentially, in essence, treaties are interesting because they're sort of an amalgamation of two countries' legal systems. So in a way, it's like a bridge, a legal bridge between one country and the other, that sort of you meet in the middle with these legal provisions, and it results in situations that are very unique. For instance, the United States citizens are accorded certain benefits here in Thailand pursuant to the treaty that, quite frankly, other foreign nationals are not granted. So for the most part, pretty much as far as it goes, it's one of the most positive things about being an American here in Thailand is the fact that the treaty provides us with significant benefits when it comes to the issue of company ownership here.